In the 46th District Court, Tracy Hall walks into the court ready to fight and win. With proof of bad service and over $2,000 on the line, Judge Sheila Johnson shuts down the landlord, tosses the fees, and restores order with one fiery quote: "You're not letting me do my job."
Case number 2400222 SC, Quinn Penn versus Tracy Hall. Okay. Your name for the record? Tracy Hall. Okay. Today's the date scheduled for Ms. Hall has a motion to quote waive storage fees.
Yes.
Okay.
Good afternoon, Your Honor. So, as you know, in December 2024, judgment was entered against me. I was never legally notified about that judgment. On May 18th, you vacated that judgment. However, because of the judgment that was entered on in December of 2024, my car was seized. It has been seized since the early morning hours of February 23rd. After you granted my motion on the 18th, I did contact Court Officer Farley that you had vacated the judgment. He then shared that there were towing and storage fees that needed to be paid, that I needed to be responsible for despite you vacating the judgment. Those fees, again, were only incurred because the judgment had not been vacated at the time. It has been since. I believe I should not be required to pay those fees because the judgment was declared invalid. Since February 2024 of 2025, I've incurred almost $2,000 in rental car fees and Uber and Lyft fees so that I can get to work and attend medical appointments. I have a broken foot. These costs for these car rentals, they place a significant burden on me, and they're a direct result of my vehicle being wrongfully seized. Your Honor, you know the law, but I just kind of, did my own kind of research. The Michigan Court of Appeals ruled in a case, People versus 1987 Mercury, that when a seizure is legally unsupported, towing and storage fees are not enforceable. Additional.
Give me the cite on that.
Okay. People versus 1987 Mercury, and then it says 202 Mich. App 545 in 1993 in parentheses. I just
545 19
App APP 545.
Yeah, what's the 1999?
Then it says 1993.
Okay. All right.
Mm-hmm. And then U.S. Supreme Court also in Peralta versus Heights Medical Center, case 485 U.S. 80 1988. But the U.S. Supreme Court also ruled that judgments entered without proper notice are void and unenforceable. So based on those rulings and the facts of my case, I'm asking for the court to consider that the towing and storage fees be waived for me. They stem from an improper enforcement of a bad judgment, and if there will be, unfair and unjust, then it's making me pay them.
Report. Okay. Fine. Huh? All right. The court just got a copy of and was reading the case that you cited. Did you want to respond?
Here for the rent she didn't pay. I'm not here for the motion. Last time we were here,
Okay, well, ma'am, this is a motion here.
No. Last time you told her to bring the proof to show she paid me the rent. I got a judgment with a money judgment that she owed me, and I have.
Okay, we're not talking about that right now. What we're talking about right now are the storage fees and who pays them.
I don't care. That's her responsibility. She didn't pay me.
It might be yours.
No, I don't even think you should grant a motion, because you ignored me. I have the proof to show she never paid me the rent. And you listened to her. And she didn't, I got a default judgment for eviction because she didn't show up that time. If you remember, the time I got default judgment because she didn't show up for the eviction, right? The first time she said she paid and you said, oh, she said. So we have to come to the trial. Mm-hmm. So we appeared in the person, she didn't show up. That's when because she hasn't paid me the rent for several months. So that's why I filed the eviction. So then she knew, the hearing is done and she just didn't come. And you gave me the default judgment for eviction. Okay. And she never paid me the rent. Then I filed the money judgment and then she never responded. And then I filed seizure property and she complained that she didn't receive the notice. If you talk to the officer, you accepted what is called alternate serve. The officer post something. And the officer even talked to the roommate she lived in. She just refused to call, make a phone call or anything. So I didn't get a chance to say this to you last time, just listen to you. And you never even listened to the officer. And you
what officer?
Mike Fairley.
He wasn't here to my knowledge.
No.
It was a motion hearing, and I did not see Mr. Farley being here.
You are the one who gave me the judgment. You are the one who signed the seizure property. So
I know what I did. Yes.
You did, but why, she lied. She said that she didn't receive anything. You just turned everything back.
Okay, hold on. Now you need to calm. Excuse me. Pardon me. You need to ratchet it down some.
Yeah. Listen.
No, ma'am. You don't need to holler at me.
Okay, I'm sorry.
I'm not hollering at you.
Yeah, okay.
I understand this is emotional for you, but you do not need to holler at me.
But I had to pay HOA fee and property tax, everything. I didn't receive any rent. I show you the proof. Okay. She didn't pay me. Ma'am, and you said she should bring the proof to show the bank the money comes into my bank. But now you are not talking about it today.
Okay. Ma'am, this was scheduled You might not understand how the process goes here. It's scheduled for a motion hearing today. You could still have a trial on the issue of are you owed rent? Nobody's saying you are or are not owed rent. I'm just saying today was motioned up for the hearing on her motion. It doesn't mean that you won't have a trial on whether or not she owes you rent or not.
Years past, I didn't get the money.
I don't know how many years it is. I don't know when you filed this case. When did you file the case?
I filed in 2023. I got the judgment on the July 13, 2023.
Okay.
It's almost 2 years past.
All right.
Yeah.
Wow.
I got the default judgment for eviction.
What we cannot do is have constitutional violations. That's what I can't do. So when and I've already ruled on this part, she came in and we said that she did not have the notice of the hearing date. So when you look back at the file, it does show that apparently when she filed her response, she put her correct address.
She never respond if I didn't get the seizure property order.
Okay.
She will, because her car is on hold by
I
the
understand.
officer. That's when she responds. Otherwise, she won't respond. Okay, that's the truth as fact I'm telling you. Regarding the motion, it's you.
Okay, ma'am, I'm gonna let you take this whole hearing over and I'm gonna listen because you apparently do not wish to hear what I'm trying to say. No. So go ahead. I'm gonna listen to
I
you.
want to speak out to see what I did. Okay,
Yeah.
you are the one who signed the.
Stop. Just sit down. Let her go. I'm not gonna interrupt her because I'm not gonna listen to this more than once. So keep going.
Okay, so you are the one who signed everything. If you think it's not if you didn't accept the alternate serve, why did you sign the seizure property? So now, because her car was under was seized, that's when she responded. She said she didn't live there. That's when she said she didn't live there. But regardless of that, okay, my point is I got to see the property order, okay? And then I need to get my rent paid. That's all I want.
We understand that part.
Okay.
For sure. So now, are you finished?
Yeah, finished.
I fully understood everything you just said.
Mm-hmm.
So what you have to understand is what I'm trying to tell you.
Okay.
So yes, she did probably come forward after her car got seized because that's when she really knew what was going on. Now, if you look, and I will be looking here at the documents here. So this started off in small claims where you said she didn't pay you rent. Okay. Then
Can I just just add one sentence here? You said I said she didn't pay me the rent, but you never asked for her to prove you listen to her. Said she paid.
ma'am, I haven't listened to anything. And I'm getting very frustrated because you don't let me talk. So I don't know what you want me to do. My job is to speak and to try to explain things to you. You're not letting me do my job. So I'm at a loss as to what I'm sitting here for at this point. Because you're not letting me do my job. You're not letting me try to explain what happened. You're not letting me explain the procedure that had occurred in here and why things happened the way they did. That's what I'm trying to explain to you. But you want to keep telling me what I already know your position is. I fully understand your position about the rent. But what you don't understand is, even though there was alternate service and that got signed, there was also some proof in this file that she never lived at this place. That didn't get, and it was filed by her early on when she gave her correct address. And he never served her there. And she never got the notice. I can't change those facts. And what we can't do, and I wouldn't do it for you. I would not enter judgment against you if you were the defendant, if you really had never received the information. So alternate service is done when it's reasonably calculated to give somebody notice of the hearing. So we look at all of the circumstances and say, well, it's reasonable that they might get the notice. But when she didn't live there, she gave us the proof of her new address. And I was going to find that here when that happened. Because this case was not filed in 2023. It was filed last year.
Because I have to wait for the time to file the seizure property.
Ma'am, I don't know what you're waiting for. You said the case was filed in 2023 and it wasn't. I'm just telling you facts. I can't change the facts. I'm looking at the dates right here when the case was filed.
So you want to see the original judgment? Somebody said,
Ma'am, I got everything that relates to this case right here. I'm looking at it right here. I don't need you to show me something that I have in my file. And I'm just telling you that you filed your small claims case in 2024.
Yeah, that is after the default judgment.
Okay. I don't know what default judgment that you're talking about.
You have everything there.
I don't know what you're talking about because unless you're talking.
The original eviction judgment.
I don't, ma'am, we're not talking about that case. That's a different case. So you're talking, okay, ma'am, it's not the same case. It's a different case. An eviction. Ma'am, you know what? You're really over the top here. I can't respond to it. First of all, I'm not going to let you stand there and talk to me like that. Okay? I'm not going to let you continue to put me on trial as if I've done something to you, which I have not. You should respect the court. And
Respect you.
No, you're not. Just look at me and you're yelling at me. What you're doing, ma'am. That's what you're doing. And listen, you're not going to have this case heard today until you calm down. So what I'm going to do is take a recess and let you have an opportunity to decide you're going to speak to me in a normal manner. When you do that, I will be happy to finish explaining to you where we are and what we're going to do today.
I think this is fair to me.
Well, ma'am, she don't think it's fair to her. Okay? Nobody. Well, we haven't gotten to the rent. We're dealing with the seizure of the car on a judgment that has now been set aside. Okay? That's what we're dealing with here today. We're going to get to your case. We're going to get to a trial on the issue. This was a motion hearing that she filed. This is not the trial date. We will have it set. If it's not set now, we will set it. And you will get a chance to present your proofs on what she didn't pay you.
Actually, I get a notice from the U.S. Postal Service. We were here last time regarding this. You said it was being referred to mediation. I have to check my mail today, but I have something in the mail from the mediation center.
Okay, well then that means we're moving forward with the process. If you got a hearing, but after the mediation, it'll be set for the hearing. But you know what? I'm not going to be stand here and let you yell at me like this. Just
Didn't they stream?
I'm sure you do. I know you're frustrated.
Yeah, I'm sorry. I also didn't mean to the.
I get it.
Yeah, I didn't mean anything like because I'm just a small person, you know. I pay the property tax. I pay everything. I didn't get paid. I don't think I'm treated fairly, you know. And because she said she paid, and the judge just believe her.
Now, I don't just believe anything. I haven't made any ruling other than the default when she wasn't here. Now
That's why she didn't. So
okay, I was trying to explain that to you, but you keep cutting me off. I was trying to explain to you what the documents in this case show, but you keep cutting me off before I could even get there to explain it to you. A person who wants to understand shuts their mouth and they open their ears to hear. You're not doing that. You're talking and you're not listening. So you're never going to get the answers to your question because you're not listening to me. You're blaming me like I'm for her. I'm not for anybody. I don't care who wins this case, quite frankly, whether it's you or her. I don't have a dog in this race.
that's good.
Okay?
Yeah.
I'm just trying to do my job, which is to tell you what's going on, how we got here, and then to listen openly with an open mind to both sides of this issue when we get there. But you're busy blaming me for something that I haven't done. And I'm trying to explain it to you because what we can't have is a violation of anybody's rights. Yes. So let me show you what I have here. Again, so you filed the case last February. Mr. Farley or whoever served this got a postal check from the post office. The postal check says at the bottom, this party, being her, is not known at this address. She didn't live there. The post office says this. Okay? And that was back in May of last year. Then he filed for the alternate service, saying that he spoke to somebody who was a roommate who said that the defendant lived there and she would have her call. And he says that person, whoever he was talking to, he was talking through a Ring doorbell. He doesn't know who he was talking to. That's what he believed he was talking to. So he said he did that the third time, there was no answer. And the postal check says not known at this address. So he went on and asked the court for alternate service. The court granted him alternate service on the idea that he was talking to somebody who knew whether she lived there or not. Okay, so that was done back in June of last year. There was a mediation in July of last year. Nobody showed up. She didn't show up. You didn't show up. That's what they said. So after that, the magistrate dismissed the case because nobody showed up. She didn't show up. You didn't show up. So in August of last year, you filed a motion asking the court to reinstate the case because you were in Canada. Okay. So I granted that. And we referred you to the mediation process. That mediation was set for September. September, she didn't come. You were there. So what happens? A default judgment gets entered because she wasn't there. Then the judgment was entered September 20th by the magistrate. Then you started garnishment proceedings and some other things. Then you did the order to seize the property. That's when her car got taken. That was back in December of last year. Then something happened after that. You were on a cruise or something and couldn't necessarily sign in. You gave us your bookings and things. Then in February, she filed her motion to set aside, just like you filed your motion to set aside the dismissal. She filed a motion to set aside the default because she wasn't able to come. She says that she wasn't able to come because all court documents were sent to an address that I have not lived at in 6 years. The occupant of the address never said anything to me about it, whoever that person was. She did not know about the case. The documents from the post office tend to validate what she's saying, that she wasn't known at that address. Then she gave us the proper address, which is on a different address. She got served at an address that she must have lived at prior to this case being filed a while back. So she gave the court her proper address. And there was a notice in the file, I believe, that showed that address that you would think the court officer who did the service would have seen. So the court, therefore, found that she never would have had notice if she hadn't lived there in 6 years. And the post office said she never was at that address that they knew. So in all fairness, the judgment should have been set aside because she did not have a opportunity to appear here. You act like she was doing it on purpose, and the only reason she came was because her car got taken. Well, that might be true because that's when she first found out about it. And we cannot allow anybody to get a judgment against them when they really haven't been properly notified. That's why the court set the judgment aside. It doesn't mean that you won't get a judgment. It just means under that circumstance, it was not proper to do it that way. And the court officer seemingly should have had some notice of the fact, but he was going off of something that somebody said who may have, I don't know who that was, but they may have known her, but it wasn't her, because she didn't live there. And let's go back to the affidavit, the first filing. Which was filed by you. You also knew of her other address because you put it right here attached to the affidavit. So she got served at an address you know she didn't live at. So it's not fair to have the judge. Yeah, this is your case, Tracy Hall, and you wrote it right here.
Is this the location?
No, it was attached to the original thing you filed last year. And it has her proper address.
Is that my address? My property address.
26877 Farmbrook Villa is where she lives now. You wrote it down. You know
What is the date?
ma'am, the date you filed the case. You filed it with your claim, with your complaint. You had her proper address, but gave the court officer the wrong address. Well, I don't know how he knew where to serve her because the case was filed under the address where I think she lived with you, which was Red Maple Court.
That's where I lived before I lived in her property.
Right.
I lived there like 6 years ago.
That's the case. So that's why this case didn't get served. You put the address where she had lived before she lived with you.
So she paid me the rent.
Right. Well,
She won't out.
but my point is that you can see now the procedural snafu that you sued her at an address that she lived at before she even moved in with you at your place. Well, that's why you can't sue anybody to get the right address. So then when we finally found out that you had it, because it was, you wrote it out. You should have a copy of your complaint that you filed, don't you?
Asking, I think what is our the original eviction and then later the
Yeah, let's show this one.
Thank you.
So you knew that she lived at a different address and she never got it. It would be patently unfair to keep a judgment against her when you knew what the right address was.
Oh, I got a two address here, so I don't know which one she live there. That's why.
Well, you had the right address and you proceeded with the wrong address on the case. The right address was the one that you put at the top. So that's why I had to set the judgment aside. She had no notice. So now that we understand that, now we're going to get back to the issue. The towing fees. So the case that you found deals with towing fees under a drug forfeiture scheme. And the Court of Appeals basically, when they looked at that, said it was two appeals really that they consolidated, and both were towing fees were at issue and the people won their cases. But it was under the drug statute. And the winners of the case did not feel that they should have to be responsible for paying the storage fees. So what the court did is they looked at that particular statute and said that the statutes do not authorize assessment of towing and storage costs against prevailing claimants in a drug forfeiture action. So they concluded that the circuit court correctly ordered that the claimants had no responsibility for towing and storage fees. Now, this is not obviously the drug forfeiture statute. This is just a regular claim where there was a seizure of property. You know, in the drug case, they talked about how the statute talks about that the court may order the person who claimed the interest in the property to pay the expenses, including, I guess, storage fees, but not when they won. And the prosecution in this case that you cited talks about how, you know, that person had dirty hands, but the court said, no, there's no wrongdoing. They the ones who endured inconvenience of losing the use of their vehicle for several months before finalization of the unsuccessful forfeiture proceedings and the inconvenience and expense involved in contesting them. After they were seized, they still were the owners of the car. So during the period that the vehicle was held in custody, the agencies that seized them remain obligated to pay the expenses associated with the vehicle ownership, such as lease or loan payments and insurance. So they said they do not view it inequitable that the instant claimants were protected from further enduring towing and storage fees during the unsuccessful forfeiture, irrespective that law enforcement may have possessed probable cause to believe that the vehicles were subject to seizure. So they may have thought that. So quite a different statutory scheme, but this is Michigan Compiled Law 600.2559 sets storage fees and says that the following is a schedule of fees allowed for process or paper served out of a court in the state by a person authorized under this act to serve process. Then section 2559H says that for levying under or serving an order for seizure of property and any paper, give the fee as $40 in actual and reasonable expense of seizing and keeping property. I then says that if the person has seized property under an order issued in an action in which a judgment is entered against the owner of property, regardless of whether the judgment is entered before or after the order is issued. And if the judgment is satisfied before sale by full payment of the judgment or settled between the parties, then there's a fee that could be assessed. So basically, this statutory scheme says that the person who's requesting the seizure has to pay this fee to the court officers. And it says for levying and seizing the property plus the actual and reasonable expenses of seizing and keeping the property under the order. This statutory scheme means that whoever requested that is responsible for paying that. And that's what this statute says. And that would be pursuant to a valid judgment. We don't have a valid judgment in this particular case because of lack of service at the proper address and an address that seemingly the plaintiff knew of, but filed the case under a really, really old address that the defendant never lived at prior to even living at the premises in question. So it's kind of instructive, this case of People versus the 1987 Mercury, and that clearly, a person, if they win a case, shouldn't have to pay for storage fees, especially under that particular statutory scheme. This was a wrongful seizure simply because it was without due process and an opportunity to be heard, because the service was really invalid here. So and I agree under this circumstances that this defendant has endured the issue of being, without her car, which was seized by the plaintiff. So it's certainly not inequitable that this particular defendant should be protected from enduring the storage and the towing fees during the wrongful entry of the judgment. So, for those reasons, I'm going to rule that first, she's not liable or responsible for the storage fees, at least at this point in time. So, and pursuant to this particular statutory scheme, where it says that the process server would be entitled to the reasonable fees, it would appear that that would fall on the plaintiff, as she is the person who requested that, and it was wrongfully executed. So it doesn't mean that if the plaintiff wins the case, that she could not claim payment for the storage fees if she wins. But right now, I'm not going to assess it against the defendant. So we'll see how this falls out towards the end of this matter. So to the extent here, I'm going to grant your motion that you're not, this juncture, liable for any storage fees for the reasons stated here on the record. And the court will hold the rest of this in advance as to once we hear the facts of the case as to who, in fact, would be liable for the storage fees at that time.
I ask Your Honor, but because you set aside that her original case or not case, you set aside that motion. Do I get my car back?
Yes, I'm going to enter an order that says that you are not liable for the storage fees for the reasons stated on the record, and that the court officer should release the car back to you.
Can I add something else? I know Miss Jessica has been so patient with me. Can I ask that, I would be appreciative if, and I don't know, what this process is, but if that motion can be expedited. I've tried to contact Mr. Farley. It's not returned calls. Again, it's been almost 2 months.
Well, he's not going to ignore court order.
Okay. But the order, you have to sign the motion though first.
I don't sign motions. I sign orders.
Oh, the order. Is there a way to expedite that?
Ma'am, I'm in the middle of a hearing.
I
I
understand. that.
can't do it this
I know right now. I know.
So-
Like I said, but it's just been all day. Excuse the court. I've been blowing her phone up. She's been very patient. I'm appreciative.
I will get the order to you after I get off this bench. I will try to prepare it. It won't come to you immediately because we don't do paper. It has to go through a process. So you might get it Monday
I appreciate it.
because we're not open tomorrow.
I'm actually leaving to go out of town tomorrow for a graduation activity for my son.
Okay. So the mediation, apparently, it was re-referred to mediation on this man. So that's the next stage of this proceeding is the mediation. Everybody, let's make sure we get correct information so you both show up at the mediation. And the mediator's job is to try to understand her position and your position. So you both should be calm with the mediators, please. You both should take what you've got. She says you haven't paid. You claim that you have paid. Then whatever you got to substantiate what you paid, you need to bring there so that the mediator could look at it and make the decisions. So what date is that?
I don't have it like I said. Oh, okay. I thought you were asking me. Sorry.
No, Judge, it says that they were referred.
Okay, so we don't know yet. Okay. But we know it's been re-referred. And after the mediation, if it settles it, then that'll be great. If not, then you will come back and we will have a trial. Okay? Do you have any questions?
Yeah, I have the Zoom. How do mediation is by the Zoom meeting, right?
What mediation is what?
Mediation is the internet, the Zoom meeting.
I think it's a Zoom. Once you know the notice.
Also have my activity from myself.
Well, I'm assuming that you'll get your notice in enough time that you could send it in to the mediators. That's what I'm assuming you could do. Yeah, hard copy.
Or I can just make it's allowed.
Yeah, the mediation, you could drop it off even probably at the mediation center and say it's for this case.
I would rather like to appear in the person.
Well, I don't control the mediation.
Can you request? So it will be better to show in person.
I don't really control how they do their jobs up there. I don't have any jurisdiction over them to tell them they have to do it in person. I don't know what their process is. I just know mostly they do them on Zoom. They may do some in person. Why don't you request of them to see? Okay, well, you could call the Oakland Mediation Center, give them your case number, and tell them that it's coming up for mediation. You got lots of documents. What do you do to make sure they get them? And can it be in person? You both can call that. It's up there somewhere on Telegraph Road, Bloomfield Township. Bloomfield.
Okay. So what if she doesn't pay? So what's going to happen?
Now, we're not there yet. We're just at mediation. So if you settle it at mediation, then you might get Well, I don't know what you're going to settle for. It might be a judgment. It might be a payment arrangement that you guys enter into, and the case might get dismissed. It just depends on what the mediator comes up with. And then if there's a settlement agreement, she has to pay pursuant to whatever the agreement is. She doesn't, then you can enforce the settlement. But you got to get there first. We're not quite there yet to determine how much, if any, is due. Okay? So that's going to complete this matter for today. Just gonna make a note. We're going to do the order after the. Okay?
Okay, outside here.
You're all set for today.
Thank you, Your Honor.
Look for your mediation notice in the mail.
Yeah, I believe I will have it. Thank you.
All right.